Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Well, hello. Welcome back, everybody. Good to see you again, Camille. How are you doing? Good. We're missing Trisha today. Poor Trisha. She had something come up. She couldn't make it, but we're here. We're here to talk about document. And what does that mean, right? And it's the age old. It's never changed. It might be a little bit more heightened right now with COVID, but what does that mean? What do you need to document? How should you document? How should you store your document, your documentation? So one of the things that we were just chatting about is let's pretend that we have a business and Trisha is our employee and she was supposed to be on this call. And at the last minute, not the last minute, Trisha didn't do that at the last minute. She wouldn't do that to us, but let's just pretend she did. Okay. She would never do that. She's entirely too responsible for that, but she's not here. So I'm going to pick on her. Let's say she did. Is that something we need to document? She was supposed to be on a call. It's during her job. She couldn't make it. Let's chat.
Well, it depends, right? Classic answer, always. If she was supposed to be here and didn't show up, that's one thing. And that's probably something that I would document, especially if it was an important call that she had missed and it, had happened before. But we all know Trisha, of course, is really responsible.
Right.
And she let us know well ahead of time that she wasn't going to make it today. And so, that's not something that I would worry about, because if it were that important of a call that necessitated her being here, we could have rescheduled it because Trisha gave us plenty of notice, that
Right.
she wasn't going to be here. And so, it's always depends upon the circumstances.
I think therein lies the problem business owners have, right? It's always in retrospect, oops, I should have documented. We have another podcast that we recorded with the plaintiff side perspective. And that was with Corinna was on with us. And she was talking about the importance of having a history of documentation, right? You wouldn't want to just document once and then let someone go. But I see this time and time again with employers. They give people a pass. They didn't document and now they want to do something.
Right.
So, yeah.
It's very common. And, as a litigator, I always want to see that kind of buildup of documentation to the termination. My general feeling is that a good termination should never be a surprise to the employee.
That's a good point.
Because you have communicated effectively with that employee your expectations along the way. You have documented along the way the issues and provided performance guidance to that employee leading up to the termination. And all of that obviously should be documented. And so that's really what we want to talk about today, is what to do, how to do it, and when to do it.
Right. And making sure you're doing it across the board.
Correct.
I've years ago had a situation where I was dealing with the EEOC on a matter, and they were hanging this discrimination case on the fact that there was more documentation on this one individual than anybody else.
Right.
Right. So consistency, making sure that you're not just documenting when the troublemakers are causing trouble, but that you're applying that same when you document and how you document across all employees.
Right. And I think the easiest example of that often is if you're documenting one employee for constantly being 15 minutes late, you need to document, maybe give each employee one pass and then start documenting everybody, but you shouldn't single anyone out because you're setting yourself up then, for a whole other, discrimination type claim potentially. And so the documentation needs to be consistent across the board with all employees.
Right. And there is some discretion with the employers to some degree of what they want to document. if 15 minutes of tardiness is just not a big deal, employees do that all the time, and we're probably never going to terminate on that, fine. You don't have to document that. But if they hit 1 hour late, then that's an issue. Okay. But making sure that you're complying with your policies, I see that quite a bit, where your employee handbook says 15 minutes is a tardy and you're not doing anything about it till it hits an hour. So, again, consistency, but there's some flexibility in when to document. What are some of the examples that you see or suggestions you have for employers about when they absolutely should be documenting? What are some of the issues that should, from that you do way more litigation than I do. Well, so what are some of those areas?
For example, no call, no shows.
Mm-hmm.
Those should be, that can be a big deal. That can, affects other employees who have to then cover for the employee who doesn't show up, and creates more scrambling than if the employer had some notice at least and could go, and have a more organized plan of how to distribute that employee's work. So those are the kinds of things, I like to see documented. A lot of times employers will have a problem employee that is evident, and they'll tolerate things, and then one day they're just done. And unfortunately, by that point in time, there's no documentation in the file. Right. It's difficult to terminate under those circumstances, because if the employer goes back and documents everything at one time, as opposed to having consistent documentation throughout the period of employment, it doesn't look as good.
Especially if they have a habit of giving people second chances. If we haven't documented that we've given you that second chance, how do we establish that this is the second chance?
Well, or that there are other employees, who have had the same issues who weren't documented.
Mm-hmm.
Right. And that's why I think the consistency is important. And listen, no employer is perfect. It's not a
well, except for us. We are. And that's why we're not writing up Trisha. I'm just kidding. Sorry, Trisha. She's not our employee. Just kidding.
But I think that it's a difficult task, because a lot of employers want to give employees the benefit of the doubt, and then it just there comes a time where you can't give the benefit of the doubt anymore.
Right. I find a lot that I'm talking to employers they're like, well, I tried to be nice. And I always say, oh, that was your mistake. And isn't that terrible? I remember starting my law firm thinking, I'm going to do this different. I'm going to be, the better employer, or not, not that I had bad employers. I didn't actually, had lovely employers. But, I could do this different and that different. I don't understand why they always have this rule. Well, now as an employer, I get it. Right. So I see where when you're trying to be nice, how you can get into trouble, especially if you're not documenting. I gave them a slide on this because of this reason, right? So that you can give that as an exception to the rule. When the EEOC comes knocking and wants the documentation and says, well, why didn't you, if you always terminate on the second chance and you didn't with this one who's not in a protected class, but this one you want to, explain to me why we want to document the difference, right? Why we made that exception.
And so I think that, you have to be careful with those discrimination claims, especially when you're dealing with protected classes. And that's why the documentation and the consistency, which is hard, like if people get busy and they mean to make a note in a file, or they mean to, sit down and do a written write-up, and life gets in the way and it just doesn't happen. Especially now with COVID, there are so many other issues that business owners are facing right now, that documenting minor infractions is not at the height of everybody's list. Especially when, every government agency known to mankind wants employers to be flexible. Documenting performance issues isn't necessarily at the top of the list, but that's why you need to prioritize what's important and should be documented and should always be documented, versus, not doing anything at all.
Right. Well, and under the Family First Coronavirus Act, there's documentation requirements, which we
Right.
don't need to go into on this episode because we have a whole another podcast on that. But it's important to know that there's documentation requirements there that that don't normally, not that they don't normally exist, but there aren't normally required. They might be optional. So that's another podcast people need to look into if they want to know what those are. I was thinking though about with COVID, with the telework situation, we're hearing and we're seeing a lot of employers now that we're reopening and we have the whole podcast on teleworking. We're hearing employees say, I don't want to come back. And I'm hearing employers say they weren't doing such a great job. They weren't doing their job. Did you document that? What proof do you have? How can we establish? Right. And they weren't thinking about documenting during COVID that lack of performance so that they can establish why the employee can't telework, can't continue to telework. Right. So
Right.
Are you seeing that as well?
Well, I think that, nothing stops an employer if there are measurable markers that an employee isn't making in terms of their job performance. There's nothing that stops an employer from talking to the employee about it and documenting it. There's also nothing that stops an employer from doing a performance improvement plan that I'm not going to get into too much here because I think we're going to do a whole podcast
Yes.
on that later. But there's nothing that says that you can't talk to and discipline or give a performance improvement plan to an employee who simply isn't meeting their, markers in terms of the performance of their job duties, but they need to be measurable. And that's the sometimes the difficult to do, especially when your whole kind of office structure has suddenly changed with employees out telecommuting and the different dynamic that goes with that.
Right. I see a lot of employers, especially more small employers that aren't used to performance improvement plans. They're not, or PIPs, they're not generally doing that. That I'm talking to now about, okay, well, they don't want to telework. Did you tell them, what was going on? No, I didn't. All right. Well, we need to talk about performance improvement plan because what they're doing is they're saying, well, let's just let him go. I want to let him go. It's not working. I just want to let him go. And well, did you communicate? Did you work with them? No, I didn't. Okay. With COVID going on right now, we're going to take that conservative approach, right? I'm not saying they absolutely have to do it. I'm not giving advice right now, but just generally, let's approach this conservatively and let's make sure that we're protecting the business against that potential plaintiff claim. Though I really am missing Trisha because, from an earlier podcast, it always resonates with me. She had that great advice of don't stop running your business out of fear of lawsuits too. Right. So we have to be careful. There is always what's the damage to the business for you didn't properly document, but you need to let someone go because it's damaging the business versus the risk of, okay, you didn't properly document. We keep them. Right.
And, I have to say, I tend to also be very conservative. I'm always looking at what's going to be the plaintiff's lawyer's angle. But that's great advice. Businesses have to continue and move on. And with that, you have to decide, and every business owner is different, what your level of risk is with respect to hiring, fire, and literally everything you do.
Right.
But just a reminder that, with COVID, we're documenting symptom checks as a lot of people are as they're coming into work. Just make sure you keep those health documents in a completely separate file from their employee records. And with that, I think it's probably time to wrap up, Susan.
Yes.
Okay. Thanks, everybody, for joining us. Have a great day.
Thanks, everyone.
Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us and have a great day.